Thank you. Okay, to the Canadian Association of Chiefs of Police, your opening statement referred to the federal government's recently announced funding plan for implementation. And on that, your statement says, quote, questions remain with regard to the resource allocation and distribution and timing, quote. So this tells me that despite what the public safety minister has been saying about that critical issue for you, you still have some significant concerns on this. And can you please tell me more about those concerns, especially given that it's already February 15th?
Well, we have learned over the last few weeks that there was a meeting that took place with the representative of each province to finalize the distribution of these amounts. So right now it's in the hands of each province to determine the way it will be distributed according to the needs. And we are expecting to get results very soon. But yes, time moves forward, indeed. And, well, we need the legislation anyway. We need the acts before we can actually start the training. So yes, we are still waiting for the amount.
There were also some important points raised in your discussion paper that you provided to our committee, and so thank you very much for the work that you put into that. And one of them I note, and you were referencing that earlier, Mr. Cox, quote, oral fluid devices cannot be used as the sole ground upon which to base a blood or DRE demand as they do not detect impairment, quote. I mean, yet again, it just seems like this with this bill, this Liberal government is just not ready to handle this particular issue. So you also raised several provisions of this bill where you recommend some important amendments, and those include the inclusion and codification of the drug categories, approved containers, certificates, disclosure of information, where you say that the provision of this particular bill will actually lead to further court delays, which we certainly don't want to see. We know what a massive problem that is, and per se limits. So I'm wondering, perhaps this question is best addressed to Ms. Malashenko, but did you propose these particular amendments to the House of Commons Committee? And obviously then the Liberal government hasn't proceeded with them because we're seeing them again now. And if you could also please tell us about two of the most important recommendations that you would make for amendment to this bill.
Thank you. Yes, to answer your first question, we did provide the working paper before the Health Committee so that they had been aware of some of the recommendations that we made. I don't know whether they had the paper at the time. I believe from what my recollection is, they didn't have it at the time that we had provided our presentation, but that was submitted to them after the fact. So they were since made aware of a number of the recommendations. In terms of those most important, we have so many recommendations that we made with respect to a number of the proposed amendments. I'm not sure one is more important than the other. I think I initially indicated we did mention some of the concerns that we had with respect to the oral fluid screening devices. That does not give you the grounds. It only detects the presence of a drug in the saliva, so not in the body. So you would still need to proceed with the traditional SFSTs and DREs. So again, recognizing that. One of the amendments we talked about was the disclosure of information, which was section 320.34 sub 1. So again, these amendments were aimed to codify requirements by saying that a prosecutor or a Crown shall disclose samples of breath that the accused provided the results of bank tests, calibration checks. It goes on further. So this concern from a policing perspective is the police may now be required to produce what's considered now a third-party record application where the police, where the defense would have to bring an application and having to establish an evidentiary burden to demonstrate that they're likely relevant. This amendment now seems to suggest that there is going to be a first-party disclosure as per the Stinchcombe decision. So the concern from us is that this amount of disclosure may not be likely relevant, but yet the police and the Crown are going to have the obligation to have to produce that. So this foreseeably may create further Jordan delays and certainly unmanageable level of disclosure for both the police and the Crown. So that's one significant one. I don't know whether Superintendent Cox, you have any further recommendations that you wish to add.
Thank you. No, I think those two are probably, I think I couldn't have picked two that were better than those two. The disclosure piece and the oral fluid screening device piece, I think, are really important pieces. There's some other changes that took place in the legislation with regards to certificates that I think potentially could cause us some problems in court. It used to be codified what would be in the body of a certificate, and that doesn't seem to exist in C46. So the expectation is that that leaves it wide open to litigation, which again could cause further court delay. So I think that's another piece that I think is important in terms of, it could simply be resolved by perhaps creating a prescribed form. Anyway, that's another one that I would suggest is important as well.
Thank you so much.
Thank you. Madam